Welcome to today's presentation. My name is Alice Hogue and I'll be your instructor. Today we're going to look at producing states' probate laws. And the title of the presentation is Pay Your Respects, Probate Laws of Producing States. What we're basically going over is what happens in each individual state that we'll look at if someone dies without a will, if they die what we call intestate. Every state has its own set of state statutes that says how property is going to pass. All of them say that the property of someone who dies without a will pass to the next of kin. But every state determines who the next of kin is differently. And so we want to look at those individual state laws and how they would apply. Now, this is important to you if you're a landman or if you're a division order analyst or a lease and title analyst. If you're a landman and you run across a gap in the chain of title, or you run into a stranger to title, you will have to go to the probate records to see how that property was distributed. If there is a valid will, how was the property distributed according to the judgment? In other words, according to the decree signed by the judge. If that person died without a will, you're going to have to know that state's laws of how property passes when someone dies without a will. And that's going to be the subject of our presentation today. So let's look at our agenda. What we're going to do is we're going to cover the state descent and distribution laws, is what they're called, rules of descent and distribution, or intestate succession, in Colorado, New Mexico, Texas, Oklahoma, Louisiana, West Virginia, and Pennsylvania. So we're going to give you the descent and distribution laws of each of those states. We'll start, though, with a probate overview. I want you to understand some basic definitions. First, I want you to understand what probate is, the distinction between testate and intestate. We want to talk about what is descent and distribution. We're going to talk a little bit about wills, and then we're going to talk about community property and separate property. From there is when we'll delve into the actual state statutes of these producing states. And if you have the new AAPL Oil and Gas Land Reference Volume, this is the 2012 10th edition. There is a great article in the back by Jim Dubuis that talks about the different state statutes. And so you can look at that. I also have a reference tool that I will include on the web page. So I just want you to be aware of those laws. And then we're going to look at trusts. Trust is something that you may see when you're doing land work. And I just want you to understand what a trust is and why a landowner would have their property placed in trust. And then we'll talk about how you transfer property based on the trust. And then we'll wrap up with a conclusion. So let's begin at the beginning. We're going to start with the definition of probate. Probate is defined as the court procedure in which a court determines the existence of a valid will. So probate occurs when there is a valid will. If there is a valid will, the court is going to look at that valid will, and they're going to determine how the property is going to be distributed. That's if there's a will. There's another kind of probate that's known as descent and distribution that applies when there is no will. That is when someone dies intestate. They die without a will. And it's defined as the division among those legally entitled thereto of the real property of intestates. Intestate is another word for someone that dies without a will. It's from the Latin, literally no testimony, meaning you left no will when you passed away. Now, note that the deceased person can die with a valid will, and if that will is later revoked or annulled as irregular, the property passes according to the state laws of descent and distribution. So let's look at the disadvantages of dying without a will. If you remember nothing else from this presentation today, remember that having a will gives your heirs options. Having a will gives your heirs options. Now, what do I mean by that? In Texas, for example, we are blessed with one of the most streamlined system of probate law in the country. In Texas, if you die with a will, you file an application for what's called a muniment of title. me write that out for you. That is a muniment, U-N-I, sorry about this, ment of title. Okay, this is if you die with a will and the estate left no debts. You file a muniment of title with the court. You wait a statutory waiting period of 2 weeks, and you basically post a notice that's saying you've filed this muniment of title. The 2 weeks gives your creditors or anyone else that has a gripe against you to come forward. If they don't come forward at the end of the 2 weeks, you appear before a judge who signs the order that is a muniment of title, and you are done. You don't have to go back to court. You don't have to testify again. You don't have to pay any more legal fees. You're done. But it only applies if you die with a valid will. If you die without a will, your heirs, who are already going to be grieving as they mourn your loss, are now going to have to deal with the day-to-day minutia of which companies, which entities require which documents in order to legally transfer the property. But if you die with a will, if you die with a valid will, you're protecting your heirs from that. Then your heirs have the option to either let the property pass according to state descent and distribution laws, or to probate that valid will through a muniment of title. Another disadvantage of dying without a will is that the court, and not you, determines the executor. The executor of the will is the person that's going to distribute your estate. Why would you leave that in the hands of a judge? Even more importantly, if you die and you have minor children and you die without a will, the court, and not you, is going to determine who will be the guardian of your minor children. There is no more important decision that a parent can make: who will raise the minor children in the event of the untimely demise of the mother and the father. So that's another key issue. You don't want a jury to decide that. You don't want a judge to decide that. You need to decide that. Finally, property is distributed per state law. That means stepchildren do not inherit. Stepchildren do not inherit under any of the state laws in the country. Another disadvantage is because property is distributed by state law, by these descent and distribution laws, no trust is created. And we'll show you sometimes how that will be a valuable tool. And so if you just die without a valid will, you will run the risk that your property will just be distributed according to these descent and distribution laws. Now, one of the reasons I enjoy giving this webinar is because it applies to you personally and it applies to you professionally. I believe that everyone needs to have a valid will. And in every state of the union, all that is necessary is it has to be, and I want you to write this down on your slide, it needs to be written, it needs to be dated, and it needs to be signed in the hand of the testator. In other words, in your hands. It's got to be in your handwriting. Okay, so every one of you right now could take out a piece of paper or a napkin or whatever you have in front of you, a sticky note, and write, I, Alice Hogue, being of sound mind and body, hereby leave all my property to, let's say, the Catholic Church. And if I sign that and date that, that is a valid will. I'm done. Now, there are more complicated will forms that you can find online, especially in Texas. I can give you a site that has the statutory forms for Thompson-Gale legal forms. If you will just email me, I'll be happy to provide that information. And there they actually have it in a Word format so that you can just literally fill in the blanks. So that is all that's required for what this is known as an oligraphic will, meaning it's in your own handwriting. Now, if you type this out, if I type out, I, Alice Hogue, being of sound mind and body, do hereby leave all my property to the Catholic Church, and then I sign that, that is not a valid will because it's not entirely in my handwriting. Now, if I take it to a notary and I get it notarized, that would be considered a valid will. But if you want to do an oligraphic will, also sometimes known as a holographic will, it has to be completely and 100% in your own handwriting. And then what I would do is I would keep a copy for myself, and I would give a copy to a close family friend. I don't recommend that you put it in a safe deposit box, because when you die, there's no one that has the authority to go into that safety deposit box but you. So you're in a jam with the bank, because the bank won't let just anyone go into that safety deposit box. And I've had people in class say, well, what if we had a power of attorney? If we gave someone a power of attorney, gave them the right to go into that safe deposit box after I passed away. Well, that's not how powers of attorney work. The power of attorney will die when the individual dies. So you can't have a power of attorney over someone that's deceased. So what I do with my will is I actually had 2 originals, and I keep one in my files, and I gave one to my best friend. And so if anything happens to me, I have a copy and she has a copy, and both of them are signed in my own original handwriting. Okay, and so now I'll get off my soapbox, but please do consider either consulting with an attorney, or I don't recommend that you use LegalZoom, because they're not specific to your state. That's why these Thompson-Gale legal forms are so good, because it's specific to Texas. Okay, so I'm off my soapbox. Really want y'all to think about getting a valid will. All right, the next thing that we have to look at when we're talking about these descent and distribution laws is the marital property rights. There's 2 systems in the United States of marital property rights. One is called community property, and we know states that have this are like California and Louisiana. Those are the 2 big ones. And then we have what's called equitable distribution states. Now, in a community property state, when one spouse dies, the property is going to be split 50-50. The community property is going to be split 50-50. One spouse actually owns an absolute undivided 50% interest, and the other spouse also owns an absolute undivided 50% interest. If someone dies in a state that has equitable distribution, and the state we'll cover today that has that is Colorado, the property is distributed equitably, but not necessarily 50-50. So the only reason you need to be aware of that is that when we're talking about community property states, they're going to distinguish between property that is community, that property is going to be divided one way, and property that is separate property. And we'll get to that definition in a minute. And that is property that is separate property is going to be distributed differently. So when we're dealing with a community property state, you have to know whether the property was considered separate or community. Now, these marital property rights are important in things like divorce or death or bankruptcy. But we don't really need to worry about it for our purposes, because the statute itself is going to spell out how the property is going to be distributed. And in a state like Colorado, it doesn't talk about community or separate property laws. That reminds me, I have for you a handout that has the state statutes. And what I've done is I have taken the state statutes from that state's website and given it to you word for word verbatim. I'm going to give you a summary in this presentation, but there's no reason that you have to rely on my word for what these state statutes say. You can read the state statute yourself. They're very logically written, and you can figure out what is being transpired. I am just trying to give you a summary of it here, a big picture approach. But one of my pet peeves is attorneys that make the law sound so complicated that you have to be an attorney to understand it. You don't have to be an attorney to read a statute. The statutes are logically written. They're very well written. To me, the law is logic. And if you are a logical person, you are going to be able to read that state statute, just like I've done to prepare for this presentation, and determine how the property is going to be split out. There's one more distinction that I want to make for you, and that is the difference between what we call intestate, and I know I've already given this to you before. So a lot of times you'll hear people say, well, did he die testate or intestate? If he died testate, that means he died with a will. If he died intestate, he died without a valid will. And they'll also use this as a noun, and that is that the person who is writing the will is called the testator, or if it's a woman, they're called the testatrix. okay? And then the person that died intestate, well, you can say they died intestate, or you can say the intestate, meaning the person that died. So I just want you to be aware of that. You'll hear those terms used. Okay, so now let's look at the distinction between community property and equitable distribution. As we said, in an equitable distribution state, the property is distributed equitably, but not necessarily 50-50. In a community property state, each meaning the husband and the wife, each own an absolute undivided 50% interest. Now, the states that have community property laws are Arizona, California. A lot of times you'll hear the movie stars complaining about when they get a divorce that the person that they were married to gets half. That's because California is a community property state. Idaho, Louisiana is another community property state. My home state, Nevada, New Mexico. Oklahoma technically is not a community property state. But if you read the statute for Oklahoma law, it says this is how the property is going to be distributed before coverture, which means before the marriage, coverture, something like that, and after coverture, or during the marriage, during coverture. All right, and what that means is it's kind of like community and separate property. In community property states, property acquired before the marriage is considered separate property, and property that's acquired during the marriage is considered community property. So technically, Oklahoma is not a community property state, but its probate laws read like it is one. So for purposes of our presentation today, we're going to treat it like it's a community property state. All right, Texas is another community property state. Washington and Wisconsin. So let's look at these differences between separate or community property. Let's start with separate property. Separate property is property that's acquired before the marriage. Property that's acquired before the marriage. If you own property before the marriage, whatever interest you own 100% in the marriage. So when I got married, my husband had a comic book collection. And at some point in our marriage, he sold that comic book collection for $3,000. Now, am I entitled to 50% of that proceeds from that comic book collection? No, because it was acquired before the marriage. Even though he sold it during the marriage, he is entitled to 100% of his separate property. Same thing if someone owns a car or someone owns a house, that's considered their separate property and they own it 100%. Community property is property that's acquired during the marriage. It's like this house that we purchased together. I own an absolute 1/2 interest in the house. He owns an absolute undivided 1/2 interest in the house. That is property that's acquired during the marriage is known as community property. So property acquired during the marriage is community property. Acquired before the marriage is separate property. Now, there are some exceptions to this. One is that gifts or inheritance acquired during the marriage are still considered separate property, even though you acquired it during the marriage. So when my grandmother passed away, she left me a sum of money while I was married. Even though I was married when I got the sum of money, that is deemed separate property because it is a gift or inheritance. It also includes damages or a settlement from a lawsuit. So if I get involved in an accident and I win a recovery, that is considered separate property, even though I got the damages during the marriage. So now let's look at Colorado. Colorado is a descent and distribution laws. Again, they're saying that the property passes to the next of kin, but it's how they define next of kin that's important. So Colorado, remember, is the only equitable distribution state that we will study. So in Colorado, we're not going to break down the slides like we will for every other one. One slide for community property, one slide for separate property. In Colorado, the breakdown is between if you die with no descendants or if you die with descendants. So in Colorado, if you die with no descendants or no ascendants, then 100% of your interest is going to the surviving spouse. Let me say, the way I teach this is that I like to use famous families. And I talk about if this famous family lived in the state that we're talking about and they died without a valid will, how would their property pass? So I'm not trying to make any kind of political statement or any other kind of statement. These are just well-known families. And I think when you see the other families, it will bear this out. So what Colorado is saying is that, let's take, for example, George Bush. George W. Bush. Let's say that he is a resident of Colorado and he dies without a valid will. How is his property going to pass if they never had any children? All right. And so what it's saying is if they never had any children, the property is going to pass to Laura. Okay. Unless George Sr. and Barbara are still living. In Colorado, if there's no descendants, but there's still living parents, George's parents are still living, Laura's going to get $200,000 plus 3/4 of the estate. She's going to get 3/4 of the estate, and mom and pop are going to get the other 1/4. Okay, so that's how that property would pass if there were no descendants and George and Barbara are still living. If George and Barbara are deceased, then Laura would get 100%. So she would get their 1/4 share. She would get 100% if there were no descendants and there's no ascendant. But we know that they did have descendants. We know that they had 2 adorable little girls, Barbara and Jenna. And so then we need to look at how that property passes if they died with descendants. Now, I'm going to change families on you because it's just easier to talk about when we look at the Donald Trump family, because there's multiple marriages and divorces in there, and it just helps our example. Let's say we're still in Colorado, and now we have descendants. I'm going to keep, just don't look at this picture over here yet. Let's keep with the George and Barbara Bush scenario. If Jenna and Barbara are all issue, that means they come from the bloodline of George and George and Laura, or they are adopted by George and Laura, they are deemed to be all issue. And in that case, Laura would get 100% to the surviving spouse. If there are descendants, we don't worry about Laura getting 1/4, and if there's living parents, they get, or how to go, 3/4, and if they have living parents, it's 1/4. If they died with children, Laura is going to get 100% of the surviving spouse. Okay. Now, the reason I turned to the Donald Trump family is because we're looking at multiple marriages and multiple divorces. And so it just gives us, it's a well-known family that we're familiar with. Everybody knows that Donald and Ivana were married. They had 3 kids, Donald Jr., Ivanka, and Eric. And then he married his second wife, Marla Maples. They have 1 child called Tiffany. I think Tiffany's like 21 now. And then he married his 3rd wife. His current wife is Melania. They have 1 child named Barron. I think he's about 10 years old right now. So this gives us a way to look at the rest of the Colorado statute. If they're all issue, but the surviving spouse has other children. So let's say all of these children are Donald and Melania's. Okay. But Melania was married before and she has 3 other kids. All right. If they're all issued, now SS stands for surviving spouse. I had someone ask me that at the end of a presentation that I did. So I should have explained that up front. So when we say SS, we're talking about the surviving spouse. So let's say that surviving spouse has other children. In that case, she would get half and all the kids would get half, would get the other half. Okay. She would get $150,000. Now, when we're talking about heirship or changes of ownership, we don't worry about this dollar amount. We're really just focused on the fractions. We're going to assume that they got their money up front. Okay, let's say that they're all adult children, but they're not descendants of the surviving spouse. So we're going to erase this. They're not descendants of the surviving spouse. So let's assume that Donald and Ivanka and Eric, Tiffany and Barron are all adult children. In that case, Melania is going to get $100,000 plus 1/2. And all the kids are going to get the other 1/2. All right. Now, if there are minor children, and we know that they are because Barron's only 10 years old here, that are not descendants of the surviving spouse, well, Barron is a descendant of the surviving spouse. In that case, it would still go 1/2 to Melania and 1/2 to all the children. Okay, so really this is saying if there are any minor children and there are descendants that are not from the surviving spouse, not Melania's kids, it's still going to be the fraction 1/2. So we can basically say 1/2 to Melania, 1/2 to the kids in Colorado. Okay, now we're going to move on to our community property states. Let's look at Louisiana, my hometown, or my home state. In Louisiana, we have community property. And under the Civil Code of Louisiana, there are code articles that talk about if the husband dies and there are descendants, all right, 1/2 of the husband's property is going to go to the surviving spouse, and 1/2 is going to go as a usufruct. Usufruct is another way, a term that we use in Louisiana to refer to a life tenant or a life estate. Okay, it is literally from the Latin, the use of the fruits. Okay, so the surviving spouse is going to have the right to use the property and the right to have the fruits of that property, but they don't have the right to sell it or encumber it or mortgage it. So that's if there's descendants. Wife is going to get 1/2, and she's going to get the other 1/2 as usufruct. Now keep in mind, she still keeps her own 50% interest. She still owns an absolute undivided 50% interest of her share. What we're talking about is how the husband's interest is going to be distributed. And if there's descendants, she's going to get 1/2 of this interest outright, and she's going to get 1/2 of this interest as a usufruct, so that when she dies, this property passes to the kids. This part of it, she can do whatever she wants. She can sell it, she can mortgage it, she can lease it, she can, rent it, whatever she wants to do. But this part of it, she cannot sell or convey or mortgage because she doesn't own it. The kids really own it. So that's how, if there are descendants, property passes in Louisiana. Now, if there's no descendants, the wife is going to get the full 100% of the 50%, and then she's going to own 100% of the property. If there's no surviving spouse, then the kids are going to get 100% in Louisiana. Okay, now let's look at Louisiana separate property. Under Louisiana separate property, if they're descendants, and I'm going back to the George Bush family, if there's descendants, let's say George and Barbara had Jenna and Barbara. Okay. George Bush dies in Louisiana without a valid will. According to the state statutes on descent and distribution, the kids are going to get 100% of the separate property. Laura gets nothing of the separate property. Okay. If there's no descendants, let's say they never had the girls. If there's no descendants, then that separate property of George Bush is going to pass 100% to the parents, okay, as a usufruct. All right, so they're basically life tenants of 100% of the separate property. And then when they die, the remaindermen, or what we call in Louisiana the naked owners. Doesn't that sound like more fun than remaindermen? The naked owners, or the remaindermen, are going to be the siblings. So that's going to be who? Jeb and I don't know all the names of them. I'm drawing a blank. Oh, Neil, I think, is one of them. So Jeb and Neil, etc. Okay, the property is going to pass to them. Again, Laura is still not getting anything. It goes to the parents, then it goes to the kids. If there's no descendants, they never had any kids, George and Barbara are deceased, and all the siblings are deceased, then and only then does Laura get 100% of the separate property. Now, why would Louisiana have a law like this? What they're trying to do is they're trying to protect property that's been in the Bush family for generations. Remember, this is property George Bush acquired before he was married. So rather than run the risk that everything goes to Laura and then Laura gets remarried and she has kids with this other husband, and those George Bush's kids will never, or the Bush family will never see that money again. So what we do in Louisiana is if it's separate property, it only goes to the wife, the surviving spouse, as a last resort. We want to keep it in the family, keep it in the bloodline. Okay, let's look at New Mexico. In New Mexico, community property. Remember, this is property acquired before the marriage. I'm sorry, after the marriage. If there's a surviving spouse, the surviving spouse is going to get 100%. Not like Louisiana, where she got half as a usufruct and the other half is, outright. No, in New Mexico, she's going to get 100%. Okay. If there's no surviving spouse, then it's going to go 100% to the kids. If there's no descendants, there's no kids, then it's going to go 100% to the parents. Okay. So we're assuming there that if there's no kids, there's no surviving spouse, then and only then do we go up the chain to get to the ascendants. Okay, so everybody got that. If there's a surviving spouse is going to get 100%. So Laura would get 100% under the Bush scenario. If there's no surviving spouse, Laura predeceased George, then it's going to go 100% to the kids, Jenna and Barbara. Okay, but if Laura's deceased and there were never any children, or the children are deceased, then and only then do we go up the chain to give it to George and Barbara Sr. Okay, that's New Mexico community property, property acquired during the marriage. Now let's look at how New Mexico handles separate property. Separate property is in New Mexico, if there's a surviving spouse, the surviving spouse is going to get 1/4 and the descendants are going to get the other 3/4. Okay, not like Louisiana where the surviving spouse doesn't get anything until everyone else is gone. In New Mexico, we're going to give that surviving spouse 1/4 of this property that's been in the Bush family for generations. And the girls, Jenna and Barbara, are going to get that other 3/4 of the separate property. Now, if they never had Jenna and Barbara, then Laura gets 100%. We don't have to go to the parents and then to the siblings. In New Mexico, if George dies without any descendants, Laura is going to get 100% to the surviving spouse. Now, if George, let's say if Laura predeceased George and there's no surviving spouse, then Jenna and Barbara are going to get 100%. And only if there's no descendants, there's no surviving spouse, does it go 100% to the parents. Let's look at Pennsylvania. Pennsylvania is not a community property state. I should have stated that earlier. So let's say in Pennsylvania, so we don't have to break it down into if the property is community or separate property. So let's look at Pennsylvania if, let's say, again, George and Laura, and let's say that George is a resident of Pennsylvania. He dies without a valid will, and he never had any kids, and his parents are deceased. In that case, Laura would get 100% to the surviving spouse. Okay, no descendants, no ascendants, Laura gets it. All right. If there's no descendants, they never had Jenna and Barbara, but they're still living parents, George and Barbara here are still living, then Laura is going to get $30,000 plus half, and the other half is going to go to the living parents. Okay, that's if there's no descendants, but there are ascendants. then Laura gets half and they get half. Now, let's say they do have descendants. We know they do have Jenna and Barbara. And let's say that they, came from the same, they were what we call issue of the marriage. In that case, Laura is going to get half plus 30,000, and the other half is going to go to Jenna and Barbara. So mom gets a half and Jenna and Barbara get a half. Okay, that's Pennsylvania. Now let's look at Texas. Anybody recognize this family? All right, this is the Brady Bunch. Now, let's say Mike Brady lives in Texas. He dies without a valid will. If all these kids are issue, in other words, if Mike adopts the girls, okay, that would make them all issue of the marriage, as if they were born from the union of Mike and Carol. If they're all issue, then Carol's going to get 100%. Okay, but let's say that Mike never adopted the girls. Okay, remember, stepchildren do not inherit under any of the state laws of descent and distribution. So if he dies without a valid will and he never adopted the girls, Carol's not going to get 100%. Carol's going to get half, and the boys are going to get the other half. Okay, that's how it works in Texas. Now let's look at Texas separate property. Separate property is 1/3 goes to the surviving spouse as a life tenant. So she owns the separate property as a life tenant. That means she cannot sell it, convey it, encumber it, mortgage it, rent it. She can only have the right to use it during her lifetime. And then when she dies, she can't convey it to anyone else. It automatically goes to Mike and Bobby and what's the other little guy's name? Peter. So that's who it would go to. 2/3 go to the heirs outright, and then 1/3 of the surviving spouse as a life tenant. That is Texas descent and distribution. Last state, I believe. Oh, no, got one more. Oklahoma. Oklahoma, as we said, is not a community property state, but for purposes of this probate laws, they talk about it. And they also talk about it if they died prior to 1985 and if they died after 1985. So you need to take that into consideration when you're looking at Oklahoma descent and distribution. When did that person die? This is how that property would pass. So let's say that Donald and Melania are married, and and Donald Trump is a resident of Oklahoma, and he dies without a valid will. If he has descendants, and he has 1, 2, 3, 4, 5 descendants, the property is going to pass, the community property is going to pass 1/2 to the surviving spouse and 1/2 to all the kids. Okay. If he never had any kids, Melania is going to get 100%. All right. If he doesn't have a surviving spouse, then the kids are going to get 100%. That's pretty straightforward. All right, let's look at Oklahoma separate property then. Oklahoma separate property, I'm going back to the Brady Bunch. So let's say Mike Brady dies in Oklahoma without a valid will. If he has descendants, and he does, if they're all issue, let's say he adopted the girls. In that case, Carol's going to get half, and all the kids are going to get the other half. Okay. Now, let's say that he never adopted the girls. In that case, Carol's not going to get a half. Carol is going to take what's called a child's portion. So he died with 3 kids, 1, 2, 3. We're going to make Carol the 4th kid, and she's going to get 1/4. So Carol gets a quarter, Greg gets a quarter, Peta gets a quarter, and little Mikey gets a quarter. I'm sorry, I'm drawing halves. Okay, so Carol is going to take a child's portion. Now, if there's no surviving spouse and he never adopted the girls, that means the boys are going to get 100%. Okay, that's Oklahoma separate property. That's if there's descendants. If there's no descendants, then 1/3 of the separate property of Mike Brady is going to go to Carol, and 2/3 is going to go to his parents, and if they're deceased, it's going to go to his siblings. Okay, this is if there's no descendants. All right, in which case we wouldn't have a Brady Bunch. Let's say there's no descendants and there's no parents or siblings. In that case, Carol would get more than 1/3. She would get a full 100% if the parents and the siblings are already deceased. Okay, that's Oklahoma, descent and distribution. Let's now look at West Virginia. I'm going back to the Donald Trump family. Let's say that Donald Trump never had any kids, okay? And he's currently married to Melania. If they never had any children, Melania would automatically get 100%. And again, that's not a community property state, so we don't have to look at whether the property is separate or community. If Donald Trump dies without descendants, 100% passes to Melania. But we know that he died, that he has descendants. He hasn't died, but we have descendants. So if he dies and all the kids are issue, what we call issue, meaning coming from the bloodline, or adopted kids, in that case, Melania would get 100% of Donald Trump's property. If they're all issue, but Melania had kids from another marriage, then she's going to get 3/5, and the kids are going to get 2/5. If they're not all issue, as in this case, they're not all from this marriage. Tiffany's from a different marriage. Donald, Ivanka, and Eric are from different marriages. In that case, the surviving spouse is going to get 50%, and the kids are going to get 50%. So the way it stands today in 2012, if Donald Trump died in West Virginia and he had his children, he had his current wife, Melania would get 50% and all the kids would get 50%. Okay. Now, when I'm doing changes of ownership as a division order analyst or a lease and title analyst, and I'm trying to transfer royalty payments, the documents that I'm going to require to change ownership in our system is going to be a copy of the will, a certified copy of the death certificate, and what's called an heirship affidavit. That is basically an affidavit that you get someone to sign that's familiar with the family, not a beneficiary, that basically gives the family history. It'll say Alice Hogue was married on this date, she was born on this date, she was married on this date to this husband, she divorced that husband on this date, and then she remarried this husband, and of that marriage, so many kids were born. Then she divorced that husband, and then she went on to her third marriage. And so it'll just spell out kind of the history. And what we're trying to figure out is who are the rightful heirs. There's no longer anything called illegitimacy. So someone that is born outside of the marriage has just as much of a legal right to be an heir of the person that of their birth father or birth mother than the other children that were in the marriage. So we're looking for any heirs out there that maybe nobody talks about that. So that's what the heirship affidavit is. We're trying to get information. Now, if the will is going to be probated, I want what's called letters testamentary. That is what assigns the executor. That says this person is going to be the executor. And once I have that, I can start making payments to the estate of so-and-so. Okay, and then if I can get some kind of judgment or a decree of distribution, I want to get that from the judge. Now in Texas, I understand they don't really have a decree of distribution, but in Louisiana they have a final order, and I think in Oklahoma they have what's called a final decree. That's what I'm looking for. I'm looking for a statement by the judge that says how this property is passed. Now in Texas, a lot of times you'll get a letter from the executor that says pass the property this way. That's how it works in Texas. So I wouldn't be waiting around for any kind of judgment by a judge. Okay, let's look briefly at trust. Trust is something that you will see when we're dealing with probate, but it's not necessarily associated with probate. So I just want to give you an idea of why someone would put their property in trust. But let me give you the definition first. And what it is, it's a right of property. It can be real property or personal property. And it's held by one person for the benefit of another. So it's a relationship of confidence or trust in which the trustee, and the trustee can be a person or an institution, assumes the obligation to hold the assets for the beneficiaries, and they can be one or more persons as the beneficiary. Now, the advantages of a trust is, first of all, it bypasses probate. So for people that don't want the world to know who got their interest, they might put their property in a trust. And the trust will say, upon the occurrence of a certain event, sometimes it'll say upon the death of the trustee or upon the death of the person who owns the trust, property will pass to these heirs. Sometimes it will give an event like when this person reaches a certain age, at that point, the property will be passed to the beneficiaries. But it basically bypasses probate. And that's a big advantage because you save a lot of money on legal fees and a lot of time, and it's not drawn out. It's just all spelled out up front in the trust itself. Another advantage of a trust is that it gives you protection from creditors. Okay, if I am Alice Hogue, and we're going to assume that I am, and I transfer all my property to, let's say, the Catholic Church. Just stick with my will beneficiary. Okay. I transfer all my property to the Catholic Church. All right. And then let's say that I file for bankruptcy or a creditor sues me for back payment of something. Can that entity, can it then go and get the money from the Catholic Church? No, they can't. They can only get money from me. If I've already given my money away to someone else, like the Catholic Church, whoever, let's say a divorce situation. Let's say my husband divorces me, okay? Can he get the money that I gave to the Catholic Church? And the answer is no, because I already gave that money to the Catholic Church. Okay. In the same way, if I establish a trust for myself, let's say it's the Alice Hogue Trust, and I even appoint myself as trustee of that trust, that's just like I gave it to a stranger in title. And so if my husband sues me for divorce, he can't get the money that's in the Alice Hogue Trust. Even though I'm the trustee, even though the trust is in my name, it's as if I gave my money to a charity. Okay, so if I file for bankruptcy, the bankruptcy court can't go and get the money from the Catholic Church, nor can they go into the Alice Hogue Trust because it is considered a separate entity. And that's one reason that a lot of wealthy people put their money in trust, because they know if they get sued for divorce, they file for the divorce, that no one can come against them. And if they file for bankruptcy, all that money is protected in that trust. Now, believe me, the bankruptcy courts have laws that say if you put this in a trust within the year before you file bankruptcy, that's considered fraud. So it's not going to work just for the purpose if you know you're heading into bankruptcy and you say, oh, let me just stash away my money in a trust. That's going to be considered fraud. So I just want to warn you about that up front. But if I put my money in trust today, and I have no inkling that one day I may file bankruptcy, and 5 years from now I filed for bankruptcy, my money is protected in my trust. Okay, so first reason it bypasses probate. Second, it's protection from creditors. Third, we're going to come back to minimize estate taxation. But third is it prevents spendthrift. Now we know, and it's a sad fact, that in many families there are people who have addictions. They have shopping addictions. They have gambling addictions. They have eating addictions. They have alcohol addictions. They have drug addictions. Whatever their addiction is, what we want to do is protect the money that they're going to inherit from being literally blown away by whatever their addiction is. So if I die and leave all my property to someone who is an addict, what is that person going to do with that? Well, they're going to spend it on their addiction. And so if we place it in a trust and we assign a trustee, the only reason a person can get money out of a trust, even if it's in their own name, is it's got to be for the health, welfare, or education of that person. So if we look at like a drug addiction, that's not going to fall within those parameters. So what we do is we keep their money safe. It prevents someone from just literally blowing through the money. That's another advantage of a trust. The fourth advantage is that it minimizes estate taxation. This is probably the major reason why people put their money in trust. So I want to give you an example of this. When you die, the federal government is going to calculate. They're going to calculate. They're not going to take it all, but they're going to calculate what your taxable estate is. This should be taxable estate is. And what they're trying to determine is if you owe an estate tax. Now, I want to be clear up front. This is not a death tax. A death tax implies that everyone who dies is going to have to pay a tax to the federal government. That is not the case. It is an estate tax. It is for people making over a certain amount of money. So let me show you how the federal government determines whether or not you owe an estate tax, whether or not you have an estate. First of all, they'll calculate all your life insurance proceeds, find out what that money is, and they'll add to that your retirement assets. That is your pension, your profit sharing, your IRA, and any other retirement assets that you have, plus all your other assets, and this becomes your gross estate. Now, from your gross estate, we're going to deduct debts, and we're going to deduct any charitable bequests that you make in your will, and that becomes your taxable estate. Okay? Now, under the Economic Growth and Tax Relief Act, this is how we determine whether or not you owe estate tax. You look at the year. Right now we're looking at 2013. And in 2013, the Economic Growth and Tax Relief Act says that if you die with $1 million or less, okay, so $1 million or less, you are exempt from the estate tax. Anything over this $1 million is going to be taxed at a rate of 50%. Okay, so if you're making $1 million or less, you are exempt from the estate tax. If your net worth is $1 million or less, you're exempt. Anything over that amount is going to be taxed at a rate of 50%. Okay, so let me show you how the trust laws come into play. So what we have here is we have a husband and wife who each have a net worth of $1.5 million, $1.5 million in their community property. Now remember, the exemption is $1 million or less. So these people, you can see, are over the exemption by $500,000. Okay, so let's say that this is, let's say that the husband dies. Okay, and all his property passes to his wife, and wife now has an estate of $1.5 million. How much is she going to have to pay in the estate tax? And the answer is 0. Spouses do not have to pay an estate tax on their spouse's income. Okay, so she will owe nothing, even though she is over the exemption by $500,000. Spouses are exempt. So when Bill Gates dies and Melinda Gates gets the billions of dollars that he has, she will pay no estate tax on it. It does not apply to spouses, but it will apply to the children of Bill and Melinda Gates, so that when she dies with $1.5 million, she's $500,000 over the exemption, and the kids will have to pay $500,000. The amount that's over times 50% is $250,000, or $250,000. Okay, everybody clear? Does not affect the wife, it affects the children. So what can the wife do to protect the children? Well, she can take $1 million and she can put that extra $500,000 that's putting her over the $1 million mark, and she's going to put that in a trust. Now, she can still have access to that money. She can even be the trustee of that money. Okay, so when mom dies, what are the kids going to have to pay? Well, mom only owns $1 million. Remember, the trust is a separate entity. So when mom dies, she's going to die with $1 million or less, which means the kids are going to not be taxed at 50%. The kids are going to pay 0 taxes. So you can see how this would be an important tool to use if you want to avoid paying the estate tax. There is a legal way to do it, and the legal way to do it is by using a trust. So I just wanted to give you an example of how trusts work and why someone would want to put their money into a trust. If I'm changing ownership and we're talking about a trust, I want what's called the declaration of trust. A lot of times you'll ask for the entire trust and they'll say, well, I'm not going to give you that. It's so many pages long. Fine. I just need the declaration of trust or the memorandum of trust that spells out the name of the trust and the name of the trustee. And then I want the name of the successor trustee. Okay, and I want the names of the beneficiaries. You can just give me those 3 documents, those 3 pages, however much it is. That's all I really need to know. And then I need a recorded deed because the property is in a trust. Remember, that's a separate legal entity. To convey it to the beneficiaries, I need a recorded deed conveying the instrument recorded in the county records to the beneficiaries. Okay, so what we looked at is a probate overview. I gave you the definition of probate. We looked at what's called descent and distribution laws in Colorado, New Mexico, Texas, Oklahoma, Louisiana, West Virginia, and Pennsylvania. And I told you these are all statutes that just pass the property to the next of kin, but the next of kin varies depending on the specific language of the state statute, which I will make available to you. Then we spent a little bit of time going over trust. I told you about the significant advantage of a trust, advantages of the trust and why someone would put their money in a trust. And then I gave you an actual example of how to calculate those estate taxes. And that concludes this presentation on descent and distribution laws of producing states. I hope you enjoyed this presentation, and I look forward to seeing you in the next one.